Welcome back to the Business Immigration Benchmark. I'm your host, Laura Bloniarz. Today's episode, we chat with Dan Maranci about all things H-1B registration, selection, and post-selection. We give a high level of the timeline. This episode's dropping right before registration window opens. But we walk you through what communication strategies you should have in mind, what should be top of mind as an immigration director of an immigration program. And we also walk through some hypotheticals. So we're hoping our listeners understand or take away the insights of what to be thinking about with some unique issues. So maybe your program's facing some of them or can gain some new insights based on the hypotheticals we discuss. And then we wrap up with some questions I'm hearing from my clients that I know are, common in the light of all these H-1B registration changes. So we hope you find some helpful analysis, helpful way to think through these changes for your program. A little bit of housekeeping. Episodes are released every Monday on Spotify and soon to be Apple Podcasts. We recommend if you like the episode, you'll consider subscribing to us on Spotify or YouTube. Please follow us on LinkedIn, where you can see WR Immigration post more interesting content about this episode and other issues within the industry. Please reach out and connect with me or Dan on LinkedIn if you have any questions or topics you'd like to see us covered on this podcast in the future. You can also send feedback, questions, or suggestions for topics that you'd like to hear us discuss in future episodes to my producer. His email is in the show notes. We hope you enjoy this episode of the Business Immigration Benchmark. Today's guest is Dan Maranci, our WR partner in the Boston office. Dan, welcome to the Business Immigration Benchmark. Can you introduce yourself and your practice to our listeners?
Sure. So I've been involved in this immigration racket for quite some time. I started out in-house working for an international healthcare staffing company, and then sort of practiced at a few different firms as a started out at the firms as a paralegal, and then I've been practicing since 2001 at a variety of different settings, and sort of working on a variety of different client accounts, which I, find pretty fascinating. The large ones have their own deal, and the smaller ones, their own deal as well.
Fantastic. Well, I'd like to summarize some of the H-1B timeline and changes. And for our listeners, we really dove into it on last week's episode with Mickey and Kimberly. So if you haven't already, check out that episode to go through all the details and FAQs related to the changes. But Dan, at a high level, can you recap for our listeners like the timeline for H-1B cap registration? We're recording on February 29th, but this episode won't drop until March 4th. So with that in mind, can you high level what's going on with the registration and where are we at?
Sure thing. And actually, while it was supposed to go live on February 28th, it opened up a little bit earlier. We were able to create organizational accounts before the actual official go live date, which was kind of fascinating. So Feb 28th, the official beginning where petitioners and registrants could create their accounts. March 6th, that's when you can start submitting the actual registrations starting at noon Eastern time. March 22nd is when the registration period closes. March 31st is the date by which CIS intends to notify selected registrants. But as we know from prior years, it can be literally the day that the registration period closes, which I believe is what happened last year and the year before. So I think they're saying March 31st to just kind of give us, this is the latest point in time that you'll hear, but very likely we'll hear sooner than that. And then April 1st is the earliest date that petitions can be filed that are selected for the registration period.
Excellent. Thanks for the summary. So what I want to go through now is, I want Dan to put yourself in the shoes of an immigration director for a program. And what are 2 or 3 of the changes that you would be considering as that immigration director in the selection period and post-selection period? What are 2 or 3 changes that are top of mind?
So, the organizational account system itself is brand new. And it's pretty clear CIS has put some thought into how this is, going to work. And it really is a much more collaborative portal between the folks that run internal immigration teams and their attorneys. So probably number one, have a strategy down for how you adapt to this new framework and just understand whose roles are whose. CIS has some pretty good materials out there that run you through the differences in the user accounts. So administrator, member, representative, and what they're each allowed to do and what they aren't really able to do. So what you want to do is map those roles to those particular organizational account roles, and then be clear on who's going to own what. The organizational accounts map to an entity too. So if you have, say, a team where one person's in charge of this group of companies, this one another, you look at it by federal employer ID number. Just be clear on who owns what, because there isn't really there's no master account that can see into it beyond. So there's like no parent organization account, which is actually something maybe they'll add at some point. It'd be nice. So just understand how that all maps out, who owns what, and who will be in charge of the registrations for those entities. Second point would be that it is now a beneficiary-centric process. So the selection process is unique to a passport that's submitted on behalf of that employee. And what we think will happen is, rather than each registration that each company had submitted in the past for an employee would count as sort of one slot against the cap, now it's really just that passport. So like in the past, if 4 companies submitted on behalf of the same person, that's 4 slots taken out of the lottery. Basically, it's 4 different entries, if you will. So then now 4 different companies could submit on behalf of that beneficiary, but it will only count as one entry into the lottery because it all kind of collapses down onto that one passport. And then importantly, the beneficiary or employee, and I'll sort of use those terms interchangeably, will be able to select which of the employers that filed registrations for them can submit a petition for them once they're selected. What this means is the bargaining power is really going to shift to the employee who may have been sponsored by multiple entities to sort of pick the one or ones that they submit the petition for. So it's going to change the dynamic around sort of how an offer's made. It's going to give them more bargaining power. And this is something that's actually quite interesting, and we're going to see how it shakes out and how it impacts and potentially changes employers' policies around H-1B cap selection and what they'll sponsor and what they won't sponsor. Also,
I think that's an important point with the beneficiary centric that I think our clients are still grappling with. So, if you're the director of an immigration program, are you doing anything different in light of knowing it's a beneficiary centric program? And like Dan said, the employee could have multiple companies move forward with not just a registration, but with an H-1B petition, that multiple H-1B petitions can be filed on their behalf. So you, as one of their employers or prospective employers filing on behalf of an employee or prospective employee, are you doing anything different?
Yeah, I mean, and I think a lot of this is really going to sort of look at it as this process superimposed over the job market, maybe even by occupation, right? Because, sure, their bargaining power shifts and they have more of it as the employee as far as this process goes. But what's the market like, and how's a company going to look at, are they going to be okay with having sunk all that expense into sponsoring someone that doesn't end up going to them? With, of course, the back of our minds, you can't collect that money back from them. At least it's not typically a good idea to try, and you can't for good chunks of it legally. So yeah, I think this is going to change again. It's going to be very interesting. This is going to shift how we look at all of this. And I, will companies come out with questions around it in the vetting process, like, have you submitted for another company? And that will be relevant depending on when you onboard a particular employee. You think of this scenario where someone's working for a company on F1 OPT. Maybe that company sponsors them. Maybe they've already reached out to a different company that they're not working for. That the candidate sort of says, "Hey, I'll definitely join you, but I really want you to submit this H-1B petition for me." It's going to be interesting to see, and we'll see what kind of data we can collect on this to find out. That's the other piece. Recruiting is going to be probably very interested to see if there are any patterns they can identify with regard to who gets filed and who doesn't, right? Like, is somebody not working for you going to be less likely to be willing to work for you once the petition, and then go ahead with the petition filing? Likewise, if the petition was filed and then approved, they still not come to work for you.
Right.
It's going to be
I haven't
interesting.
seen any of my clients make any policy changes or ask any questions in their onboarding or recruiting process around this H-1B centric change. I think, to your point, we'll probably see some changes based on how companies experience this new system. So that's all to say that we're not seeing any companies change how they're sponsoring or their tolerance and appetite to sponsor in the H-1B cap registration. But I sense that pending how this year goes, they may change policies. I've heard other companies have a 1-year employment policy before sponsoring H-1B registration. I think, we might start seeing that to be more common. Currently, my clients don't have that. And in fact, most candidates, especially in an F1, have an expectation, even if they're a prospective hire, that they would be put into the cap when they sign their offer. So we'll see what changes come next year. We're not really sensing any companies changing policies so far. Does that sound right to you?
Yeah, definitely. And I think, it's going to be really interesting to watch this unfold for sure. And again, I'm going to be interested to see how it affects different segments of the workforce. You've got tech, and when they go into the feeding frenzy mode, they tend to, be a lot more generous with what they're willing to lay out for talent. And we're kind of in an in-betweenish sort of mode for that, I think. And then other occupations, we'll see. And my suspicion is it's going to focus more on, candidates not employed right now. What do you do with, how do you treat them? I think we'll maybe see some changes or maybe some more fleshed out policies next year on this.
Yeah, we'll have to come back next year and revisit this episode, revisit our thoughts and see where we're at. Which brings me to my next question. So Dan, I'm going to brag a little bit about you. You are very humble in your introduction of yourself. So allow me to expand on Dan's experience in corporate immigration. Dan, he led an immigration program that was one of the 10 largest companies in the world. So massive amount of foreign nationals under his docket review, and a really complex corporate structure you were navigating. And, you were overseeing massive year-over-year growth. And like all things in corporate immigration, there are changes to USCIS policy, USCIS adjudications, processes. So you've managed a lot of change within a massive program. So, when you reflect on your experience managing those types of programs, and in light of today's changes, what are you thinking about? What are you counseling your clients in light of these changes?
So I think you just, as with anything, just prepare as much as you possibly can in advance. And I would suspect most of the super mega hyper large programs have done just that, because you can't really approach this sort of new framework without really kind of having it all lined up well, especially when you're talking about super large volumes. So I'd say, understanding your entity structure. Again, if you've got a complex set, like family of organizations in your sort of corporate org chart, who owns what, be very clear on that. again, because of the structure of how the accounts are set up and the roles, right? So like if you've got a giant organization, you can't have just one administrator sitting over all that. You're probably going to want to chop that up by company or groups of companies tied to FEIN again. So all that should be mapped out. And then, hopefully they're leaning on their legal representatives to do most of the legwork, which of course they can. There's not really much you have to do to sort of create that first company administrator account. And really what we're doing with our clients is and literally I sat on a screen share with a client like a couple days ago, again, because they opened it a little bit early. And we just walked them through, here's what you put in there, here's what you put in there. And then, enter our info as representative. And once that happens, we can create basically, all the registrations that would then really just require approval on the behalf of the client administrator. So, yeah, I mean, I think that's one piece. Then, big sort of obvious important thing is if you've got a massive complex program, the one thing that CIS has warned repeatedly is we're watching for duplicate filings, which they always have in the past. Because, the consequences can be, they're going to scrutinize your program for one thing, and then they'll invalidate that entry, which is a bad experience for everybody, especially the employee. Then super probably important as far as what you call sort of, different companies seem to call it different things. You call it contingency planning or at-risk planning. What do you do with the folks that are not selected, that really don't have any other options? If you're a large multinational corporation, you've probably already talked with tax, relo, stakeholders in those foreign entities to basically have some sort of methodology or framework in place for how you might transfer them outside the US. So those would be sort of the main things I'd be looking at when it comes to the really large programs.
Yeah, it sounds like a lot of the guidance is around like change management and effective communication, which is not really like legal counsel, but rather like effective structure, process, workflow. And, how do you work with your clients to sort of create that or, influence within a complex corporate structure? How do you help them communicate change management and change in workflow? Do you have any hot tips on that?
Well, one thing is to go through it a lot of times, and it's a sort of iteration process, really, and having done it for over a number of years, you learn the things that you should have thought about last time, and then you incorporate them into your model going forward. But I think literally just sort of, so what we do is we provide essentially that framework. Like here are your last chancers, if you want to call them that. And then here are the different sorts of possibilities. Do they have a potential family-based case? Are they, is extraordinary ability possible for them, an O1 visa? The foreign assignments are a big one. And the foreign assignments, so in other words, sending somebody out, who knows, sometimes they go and they never come back because they like wherever it is that they went. And if everybody's in agreement, it works out fine. But if the ultimate plan is to have them return in a role, either the role they're doing or something similar, then you want to understand, obviously, the time frame to getting a work permit and wherever that is. So you're going to want to work with your firm, and that's what we do on the global side, is scope out, okay, here's how long it's going to take based on this person's profile. And thankfully, typically if they've been working with you in the US in some kind of a reasonably specialized role, I think or managerial, then you typically have more options with what you can do with most other jurisdictions, most other countries. And then understand what the time frame is for them to come back. How long will that take? What are the rules around what they have to be doing there? What are the different options? We always like to look at, so if they're, especially if they're from a backlogged country and have a long green card wait, could they, even if maybe they're not in the role right now, could they work in a managerial role outside the US, meeting the definition? And then
we'll talk more about contingency planning post-selection with some hypotheticals I've prepared for you.
Oh, sorry about that.
No worries.
I jumped the gun a little bit.
No worries. No, I know we're excited to talk about them. The last thing I would say just on change management or change process flow, I think one thing that I've learned in my practice, again, this is not the legal counsel, right? It's just effective communication is, the longer you work with the client or when you're beginning to work with a client and their company, it's like understanding their company culture and the way they refer to employees. Maybe they call them staff members, whatever it might be, and sort of mirroring the type of communication that resonates within their company culture so that, if we're preparing the notices or the communication that the director's sending out, we're adapting the way we're communicating, not just to our client, but the way that the client needs to communicate to the impacted employees. So being sensitive to not only that this is a stressful time, but that there are some unique company communication protocol and building that in. So if you're new to a company and you're in charge of a program, kind of understanding and, maybe finding a mentor, like what are some of the sensitivities in the way we communicate or the language that we're using to influence change? Because that can be really hard, especially during a really sensitive time period that's so impactful for many foreign national employees.
Yeah, that's a really good point. And also goes back to the policy issues too. So again, the more you work with a company as their legal representative, the more you know what either their explicit policy is or you've worked with them in the past and here's what they do for whatever. Because obviously the last thing you want to do in a situation where you're contingency planning for an employee is to sort of have a potential offer of some possibility that is not possible. It may be possible from an immigration perspective, but it's not possible from maybe a tax or a relo or some other, some other angle that is super important internally. So again, being sensitive about how you communicate and what you communicate. You just have to be really careful, and then help the company, sort of crystallize those policies, make them as explicit as possible. And maybe they also want flexibility. So factor that into your comms as well, for sure.
On that note, I want to transition to talking about what corporate immigration teams should be thinking about following the end of the registration period. So, when this episode airs, we'll be sort of just embarking on the registration period. And so I really want to run through some hypotheticals. So I feel a little bit like law school, Dan, about, different programs and how they should be thinking about the selection period and post-selection communication plans. Does that sound good?
Yeah, it does.
Okay, cool. So the first scenario, we've got a head of global immigration mobility. It's got 4 members. So we've got a director with 4 team members. 2 are responsible for the US. 1 is responsible for Canada. 1 is responsible for EMEA. So this is a large global program, 700 foreign national sponsored employees in the US alone. And their program is majority H-1B, F1, OPT, CPT, STEM, EAD. So that's about 85% of their program is that H-1B, F1 population with, a handful of then TNLs, H-1B ones. So mixed soup there. The corporate immigration team expects to submit about 100 registrations in the CAP this year. Dan, if you're working with the head of global immigration mobility at this company, coordinate her internal team and outside immigration counsel, how are you working with them to communicate selection and non-selection notices with this type of program?
Yeah. So again, you go back to being well prepared in advance, understanding your population and understanding which ones are the at risk and which ones are, have enough to carry them into at least another CAP lottery. So in terms of what you're looking at the sequence of filing is one thing you need to plan. And aside from sort of that analysis of who's who is this the last chance? Then you look at, who needs it fastest, who needs that cap gap work authorization. And then you prioritize by, some sort of tiered system. These go in first. You may advise that the petition itself should be prepared in advance, ready to go, because their OPT expires on April 2 or something like that.
And so that's what you mean by sequence of filing based on their sort of need of max out of work authorization.
Yes, exactly. Yeah. So rope those off, have them ready to go by date. Then one other piece, and we kind of sort of a theme of policy, you want to also understand what your current policy is and anticipate the questions that you're going to get around filing. And one big one is the sort of consular versus change of status for the H-1B. You're going to see typically a lot of F1s are quite well aware that, some do not need to have FICA taken out of their paycheck. And in fact, you shouldn't. That's a tax analysis. But those that are aware of it are going, in some cases, going to want to keep that money in their paycheck and hold on to that F1 status as long as they can. And so they're going to probably be pushing for consular filing. So policy-wise, you can definitely do that. But, we've worked with some clients where they actually, will very strongly encourage, if not, mandate that they file as change of status, because you only get so many chances at the H-1B lottery. If you're selected, filing as a change of status is the sure way to ensure that you are never subject to the lottery. Well, maybe not never again, but, for all practical purposes, never again. If you choose consular, then you have to obtain a visa stamp at a consulate outside the U.S., and arguably also have to re-enter and take up work for that employer in order to now be exempt from the cap and not have to worry about the lottery again. The issue there, though, is if there was a separation in employment, you were not able to activate it. You now can't change employers on H-1B status because you never activated the H-1B. So now you're subject to the lottery again.
So it sounds like, in a program this size, you're building out FAQs, and perhaps your legal team is providing that. And again, you're probably thinking, how are we effectively communicating this to the foreign nationals? I know with my clients, we do a town hall before the registration. So they give them the overview of the documents, information needed in which to register, but perhaps the sort of post-selection FAQ, and then how you're communicating that, because does everyone read the FAQs, things like that, depending on the company you're working with and how they receive information. You're building out this, are we recommending change of status? Is consular notification the exception? And how are we dealing with those types of exceptions based on the company policy? Because the next question is, if I'm going consular notify, will the company pay for my visa stamping, travel, and appointment? And so depending on how robust your policy is at your company, you may or may not be covering that, and you'll want to have those answers prepared because that's the sequence of the questions we get from these employees.
Yeah, absolutely. So it is important to do that. I like your point about, the FAQs and, it's sort of like an informed consent kind of situation, because, it is true. There's a lot of information out there, not just from, what we create for our clients, but we also give thought to, what's the format that people want to absorb this in. So we have videos as well that will have the clients share with their employees and that they can access, because different people learn in different ways. But that's a super important point, where I think it almost goes beyond just informing. There has to be an explicit, and I think we typically default to that needs to be acknowledged, explicitly, because of the potentially really severe impact down the road of having to potentially be entered in the lottery again.
Yeah, absolutely. Okay, so that's hypothetical one. Moving on to two. This one I like. This is the one woman explosive growth program. So we've got the one woman HR specialist, and she's the only person at our company's internal corporate immigration team. Initially, she's managing a program that was about 50 foreign nationals, but in the last 12 months, that spiked to managing a program over 130 foreign nationals. And this is based on some acquisitions the company made. So she might be dealing with some successor and interest issues, and that she's expecting to register about 100 H-1B registrants. And of those, many of them are these prospective hires. So they might have a program where they're giving offers to, grads in June, with their U.S. masters, that they'll effectuate the graduation, and the offer is contingent upon completing graduation. So this is pretty common in certain industries. So when you're supporting this woman who's probably overworked, overburdened with, managing this explosive growth program with a lot of complex issues, how are you counseling her and managing post-selection results for a program that has all these prospective hires?
So, first of all, we can help with literally all of that. So again, to let you know, we have clients like this. Just lean on us. We'll literally walk clients through how to sign up for the registration process. But we can also help with, again, we've been through this a number of times. So sort of going back to that point about comms, we have comms that we can sort of deploy and kind of give you the sort of best practice framework based on similarly situated clients for how you deal with these situations. Right. So there's no need to, we can pretty quickly hone in on issues like, the person graduating with their degree and when is it going to be issued, and what category should they be filed in, the advanced degree cap or not. We can sort through all of that directly working with the employees to find out when can you get that degree. And if you can't, here is the specific format that your registrar can print out a letter with and supply it to us. And as long as we know that it will be issued and you can guarantee that's the case, we can file you in the advanced degree cap, and we can completely manage which one it is without that beleaguered contact at the company having to deal with the person maybe yelling at them, because maybe that degree won't be issued until after the lottery period, the filing period has run, and we can communicate. There's no reason for internal folks to have to deal with the fallout there. Just punt it to us, or better yet, just let us handle the whole process, so you never got that question in the first place. There's a
great.
few other.
Go ahead.
No.
I just wanted to say the other piece of this with the prospective employees, I think, as we discussed on the top of the hour of the show, that it's a beneficiary-centric program. So with this prospective employee, these might be the employees or the candidates, however the company refers to them, that are sort of the least sticky to the company and may have a number of prospective offers. So I think in a situation for a company like this, there might be a memo or notice to the managers of those prospective employees that we would want to prepare and just say FYI, you're expecting this employee to onboard on this date, given some changes in how the H-1B registration program is working. This person may not onboard given the results. So managing the manager's expectations, who's expecting that resource. And then I think this is going to be something we're going to be wading through that's going to be a little bit tricky, is understanding when that employee, whether they disclose or not, their sort of selection results and multiple registrations being filed. I think sort of just letting people know that what you're expecting with this onboarding of a resource may not happen given the shift in the balance of power for these H-1B registrations. So historically, you had the company had a lot of power, and this is shifting that power back into the employees' hands. So just putting people on notice, because the worst thing that manager might feel is if they don't have the resource on board in the time frame that they think they're going to be onboarded. So just there's a possibility, right, of something changing.
Yeah, and it's their budget, so again, this is going to be really interesting to look at, next year after we have some data around these potentially changed patterns of candidates onboarding or not onboarding.
Yeah, and I'd be curious to know, like, within that pool of H-1B registrants, which ones are staying at the company and which ones are, selecting other registrations. And I think that probably has to do with, like, maybe their tenure with the company. Like, let's splice that data and see really where it ends up. So that's what we'll be.
Yeah.
Dan, we're gonna come back and figure that one out once
we will.
Once we get it.
It'll be very interesting, and we'll do some benchmarking around that too.
Absolutely.
So,
yeah.
TBD.
Heck yeah. Okay, so moving to scenario 3. This one is U.S. immigration manager at company with about 204 nationals and has one immigration specialist on his team. So it's a 2-person team. He just took over the role in December and oversaw the process of the company switching U.S. immigration law firms. However, the transition process from the old firm to the new one is not going smoothly. In addition, the company did a 10% reduction in force in early January, which included several foreign nationals. As a result, the immigration specialist on his team is bogged down working on the transition and the fallout from the reduction in force. So sounds like a lot of issues. Transition, reduction in force, both really tough to manage, especially if you're new to the company. The company expects to submit between 30 and 60 registrations in the lottery, but the corporate immigration team is way behind on creating organizational accounts and finalizing its registrations list. Many foreign nationals are anxious about registrations being submitted on their behalf due to the company's recent change in law firm, January reduction in force, and new H-1B registration processes. How would you consult this U.S. immigration manager on taking the program forward through this H-1B cap season?
So, yeah, again, this is sort of stuff that falls outside of the, I'm an immigration attorney and I'm going to give you, a memo about how this is going to work. This is a pretty charged situation. People are, again, this is huge impact stuff. If something falls off the conveyor belt, it's somebody's life, and potentially having to uproot and, lose work authorization, stuff like that. So having been through many a client transition and bringing them over to the firm, we have implementation down really well, and change management is some sort of a skill set that we've got pretty well developed here. I'm a big fan of the town hall. Just open it up, maybe chop it up by stakeholder depending on the size. Like if you want just the managers to have a session, or you want managers and employees, or just sponsored employees, I think those are great. Make it like an AMA format. You usually will tell people, you're in front of a lot of people, so try to keep the questions high level. And then we'll just say, look, if you've got a specific one, we will usually set up an inbox that's just sort of specifically for that company to use, like client name at wolfstorff.com. And we'll just sort of very prominently say, send us your questions. We'll get right back to you. So, you want to allay people's fears. The RIF is sort of another thing that we're pretty experienced in counseling clients around, both on the impact to the green cards and just sort of if the client supports it, counseling the termed employees that have immigration statuses around, what their options are and what they should look into for timeframes. So again, too, if it's a stressed and under-resourced department, just lean on us. That's what we do. Like we can hop on a screen share, get you through registration, maybe in like 10 minutes, and then just leave it to us. And we take care of it in terms of vetting your population that's going in for registration, contingency planning, all that stuff. And that's what we kind of tend to do. Just pare back the things you don't need to deal with, making the high level policy decisions with us that we can then turn into comms and kind of put into how we handle your process, into our emails and all that kind of stuff. And, we review the files from prior counsel. That's our job, to catch whatever mistakes come on board, because once that data comes in to our system, we need to know it's correct. And that means we go through looking at PDFs. I'm doing that right now. I actually find it interesting.
That's what I was going to add, the auditing of data and the transition, especially a program that's facing some pretty complex issues like a shaky transition and a reduction in force. You want to be auditing the data immediately because that's going to help set up ensuring your compliance is covered. You're not missing anyone. No one's falling through the cracks to be included in the H-1B registration. That would be sort of top of mind where like, did we get everybody? And so you're going to want to audit the data and you're going to want to look at I-9 data that maybe, Immigration Counsel didn't or did not handle, or who your I-9 team is, to sort of be the backup source, especially sort of immediately in this H-1B registration period. And then to your point, Dan, about contingency planning, you're going to want to make sure the data is right so that you sequence the filings correctly, like you mentioned earlier, addressing everybody's like immediate need, and then making sure no one falls out of status. So it's like a top compliance concern in this transition and registration period. Any other thoughts on this one?
I just think it's. I wouldn't want to have to go through that a riff right before cap season with a transition to a law firm. But it's a lot about quality control and a lot about, it gives you also the chance to revisit your policies too, even though that's obviously not going to be at the top of your mind. It'll be in the backs of our mind as we're looking at what your program looked like and what we think might actually make it function even better, because we'll have dealt with peers and have benchmarking info and stuff like that.
Yeah, great point. So now I want to move to some rapid fire technical questions. I know they're not necessarily rapid fire because we want to be technically correct, but let's start. How can companies work with multiple law firms in the new system? Is it possible?
It is possible. You can create registration accounts for multiple law firms, and that's a good thing in that there are a lot of huge programs where they do work with multiple law firms. But I do think that, when you have a program like that, the obvious, warning that we keep going back to is guard against duplicates. You really don't want that to happen. So most of the data can be extracted right out of the registration system anyway. So my advice would be, before you submit a new batch or your initial batch, have all that data in front of you. Somebody should be designated as owning, policing duplicates, and just maybe put two sets of eyes on it, because the impact is obviously pretty severe.
Good point. Okay. In this new beneficiary-centric system, how will a company know whether their employee had multiple registrations and potentially multiple H-1B cap petitions filed on their behalf?
Well, when they tell you that they did, mostly. And again, it's going to go back to what's going to come out of all this, because the sort of things that can happen, there's a lot, and where that person ends up, you just don't know.
Fair enough. In years past, the online registration process required a handshake process to submit the registrations. What will be the submission process? What will it look like this year?
This year, they've sort of changed it up a little bit, but it still entails an approval from the administrator of that particular organizational account. But they've simplified it a bit since, and there's less sort of emailing back and forth that will need to happen, thankfully.
Okay, hopefully it looks a little bit better.
No.
How late in the registration window can the client initiate a registration request and expect the law firm to be able to complete the registration timely? This is kind of a subjective one. What do you think?
I mean, I am a sort of a real pushover, so I'll do a registration up to the minute that it closes, and have done for clients too. And inevitably that's going to happen. So, don't sweat it. You're not going to stress us out. We can manage it. It's not a super complex process. I mean, we do have to do some analysis, obviously, to make sure that we're putting them in the right category. and that it is a viable H-1B if we have to actually file a petition for it. But yeah, no, we do them right up to the last minute. Obviously, we prefer getting them as far in advance as possible. But same day, we're not strangers to that.
I'm sending all my H-1B registrations to Dan's team. The last question. What happens if the company terminates the employee's employment after the employee has been selected in the lottery? Is the company still obligated to submit the H-1B cap petition on behalf of an employee that it is terminated?
It's not obligated to submit the petition, sort of unlike how it works with a perm audit situation where you do have to at least provide some kind of response, or the consequences, there can be a consequence to your sort of program in general. But in this case, no, you don't have to submit it. There were some sorts of warnings around, I think what CIS wants to prevent is the kind of gaming of the system, like, basically we really saw last year with companies that very explicitly sprung up for the sole purpose of submitting a registration for somebody to increase their odds. I think as long as your percentage of cases that don't move forward is pretty small, you're not going to come onto USCIS's radar as like, a registration factory. But there's no obligation to submit that petition.
Yeah, as long as you're acting in good faith, I think you're good.
Yeah.
Well, that wraps up the questions. Dan, thanks for joining us and for all your expertise advising us on these hypotheticals for post-selection and selection results in the H-1B registration this year.
Well, thanks for having me, Laura. Anytime.